Mike, you know, could you give us some of your experience and best practices that you've seen for um, triaging um, reports of potential misconduct?
Sure. Thanks, Matthew, and thanks for having me on this panel. I'm delighted to be here. Yeah, the DOJ guidance says that a starting point for evaluating a compliance program generally is to understand how the company has identified, assessed, and defined its risk profile and the degree to which the company devotes what it calls appropriate scrutiny to the spectrum of risk. I think this is obviously applicable to compliance programs generally, but I think those themes also carry through to how you evaluate matters that come through whatever it is that you're using for your hotline function. I've found that it's really helpful to sort of risk rank matters that come through, and so doing that actually, gives you a framework to evaluate what probably is the threshold question, right? What needs to be investigated versus what needs to be reported out to other parts of the organization, but doesn't necessarily rise to the level of an investigation. And on that point, the DOJ guidance is helpful there as well. It asks, how does the company determine which complaints or red flags merit further investigation? To me, that suggests that the DOJ is at least acknowledging that not everything merits further investigation. So I think it's helpful to have a framework in place to evaluate and to essentially put complaints or matters that come through your hotline into buckets, right? So at the very top level, as I said, distinguishing between things that need to be investigated or further followed up on versus things that perhaps don't, right? That you can pass off or provide to another member of your organization. And in that latter category, I'm thinking about a lot of HR issues. The guy in the next cubicle is making popcorn in his stall again. Those sorts of things. And then in the former category, of course, there's a list of matters that are potentially worthy of investigation. And then I think you can even get a little bit more granular than that, right? Think about the risks that your organization encompasses on a daily basis and rank those, right? I would suggest using some of the factors that we see in SAB 99 for evaluating materiality. Look at sort of the nature of the misconduct that's being alleged. Does it involve potentially senior level people? Does it involve, conduct that one would consider to be intentional or reckless? And then within the spectrum of things that you decide to investigate, you can put them in the buckets there as well. And that's also really helpful, not only in assigning investigations, but it's also extremely helpful in reporting out on the backside. You can give executives and stakeholders within your organization a little bit more sort of transparency into the nature of what you're seeing through the hotline if you can sort of break it out into buckets in terms of reporting out as well.
Then on those buckets, I mean, do you prioritize certain buckets over the others as far as how fast the investigation goes versus and resources that you utilize for it?
Yeah, I mean, they're obviously not in terms of the time periods applicable, because I think that the matters that have the highest level of risk are the matters that necessarily are going to take a little bit longer. More complex accounting matters, potential corruption concerns. Those are going to involve more in-depth interviews. Those are going to involve, people potentially, getting on a plane to conduct those interviews or pulling data. And so I think you need to think about, who's going to handle those, right? Is that going to be an attorney? Is that potentially going to be outside counsel? Is that going to be, if you're fortunate to have in-house investigators, are they going to handle those? You want to separate those from, matters that potentially involve a violation, but are, of a lower risk level, right? A conflict of interest, travel and expense violations. you might assign those to someone from HR or another part of the legal department.
Well, that brings us to a good point. I mean, I've seen with certain clients that there sometimes can be, whose turf is it? And is it an investigation for legal and compliance? Is it something that HR should handle? Is it something for internal audit? And I mean, and there's certain allegations where you could, presumably it may make sense for all of those to perhaps participate. So, David, when we were preparing for this, I thought it was really interesting the approach that you took on this. So could you talk a little bit about how you went about deciding how to handle the investigation internally?
Sure. It's sure a pleasure and a privilege for me to join such an esteemed group, not only in this session, but I've been listening to all the sessions and been remarkably impressed by the professionalism of everyone that I've listened to. And it's been a real pleasure for me to do that. At the organization that I was at for the last 19 years, what we found was that in determining who should conduct investigations, there are obviously all of the options, and everyone seemed to want to grab their piece and protect turf. You had internal auditing, you had HR, you had legal and compliance. And of course, I think that the assessment of this follows some of the same principles as when you're trying to decide where should compliance fit within the organization. And I know there are different schools of thought. We looked at that very carefully as we were making that decision, and we benchmarked it. And what we ultimately decided to do was to place compliance within the law organization. And I think the reasons to do that are very similar when you're making the decision as to who should conduct investigations. What we found was that human resources and personnel and internal auditing had a tendency to investigate whether or not a company's policy had been violated, but they didn't look to see whether or not a legal standard had been violated. And so what we found was that it was important to be able, particularly when doing a regulatory investigation, to take a look at the matter from both a company policy perspective as well as a legal perspective. And so we determined that it needed to be in compliance. We found that the support, the manpower, the resources that internal auditing could provide were indispensable. And so it was important to approach this in a team effort. Our internal audit, special audits group is made up of former FBI agents and MI5 officers, Scotland Yard, and other law enforcement, IRS and USAID, different agencies. So there was tremendous expertise, but it was important that there be a lawyer there to guide and direct for a couple of reasons. One, to be able to identify the elements of legal standards that needed to be investigated and to make certain that everything was done the way that it should be from a legal standard. And the other reason was obviously to cloak it in privilege if privilege was applicable. I know we'll talk more about that later in our session, but I felt like that was important to do. And so as we would get these reports coming in, we found that they could just come from any number of places. Information could come from outside the company or inside the company into compliance. The business ethics office was a part of the compliance organization that I led. So I had business ethics also reporting into me. It could come from red flags that were identified during internal audits, operational auditing of business lines, which they normally were doing. It could come in from complaints to our HR or personnel departments. It could come from our corporate security, or it could come through the hotline. And so we would get all of these. And what we did was on a weekly basis and more frequently, if necessary, is we would hold what was called an intake committee meeting that had representatives from all of these organizations. And we would look at the allegation, we would ask questions about it, and then make a determination, is this just someone who doesn't like their performance evaluation and it should be referred to personnel? Is it someone who's complaining about a neighbor in our residential community, and we would refer that to corporate security? You know, is it a violation of some sort of a contractual issue that should go to internal audits? You know, or was there an element of a regulatory violation? And if there was a regulatory violation aspect, then it would come into the compliance department, and then we would do the investigation. And so it would be under the direction and supervision of an attorney, and oftentimes would then involve our auditing and sometimes outside counsel, depending on the nature of the allegation.
Oh, that's fantastic. I'll cover one more topic on the intake and assessment side. And Mike, I'm going to ask you about, you know, best practices for tracking investigations and your thoughts on, you know, how to best do that.
Sure. I've seen it done a couple different ways. At the SEC on the enforcement side, they used a system called the Hub, which was just very simple, you know, logging in on a quarterly basis, and then, you know, providing sort of the background and the current status of the matter, and then any other information that you thought was appropriate, and then taking the information out of the Hub and going and talking to the supervisor on a quarterly basis. It could really just be that simple. The point is that you do it, right? That you are tracking culture where people are held accountable and are taking ownership of things. It is absolutely vital to the larger organization and that they can see that you're actively working on things and following up on them. On the private side,
Well, it looks like Mike's video may have, you got to love the world of virtual conferences and learning and adapting to this. It looks like he may have froze up a little bit. So, and then now he's kicked off. So we'll give him some time to get back involved. One of the things that we had talked about, and I'll fill this in, is, and David, feel free to chime in as well, is,
Sure.
you know, for tracking investigations, you know, it's really just, you know, it's just the benefit of technology, right? It's the ability to use that technology to not only track the status of the investigation, to talk about, you know, making sure that there's been, you know, remedial actions that have been taken. We'll talk about that a little bit later. But I think, you know, one of the points that Mike was making to David and I was, you know, it allows the benefit of getting insights into allegations. In other words, you know, are allegations coming from the same particular office in a particular country, and does that signal an issue that it may not necessarily be at first apparent, because you may have different people within the organization looking at investigations into issues, but having that information in one spot, maybe you're able to identify, maybe we have a bigger problem here, maybe we have a tone or management problem, or maybe we just have two employees who don't like each other very much and are going back and forth. So I wanted to, the second topic that we wanted to address was how to handle allegations involving senior management and or illegal activity. And so what I'll go ahead and start my, I was going to talk a little bit about when to notify outside auditors. Hopefully Mike can join us here very soon. But when you're dealing with allegations of senior management and or illegal activity, as Mike was talking about, I mean, these are things that under the accounting guidance are things that have potentially material impact on the financial statements of the company. And so from a senior management standpoint, you have senior management either making reps and to the auditors and management rep letters, signing certifications or sub-certifications in those financial statements, maybe overseeing critical internal controls over financial reporting. And then, of course, illegal activity may just have an effect upon operations and the revenue or expenses that are being reported. And so one of the keys that I've seen from being an outside counsel here is usually there can sometimes be a little reluctance to notify the auditors. I mean, of course, you need to triage the allegations and determine if there really is potentially something there, and not necessarily are the allegations true, but are they do they have some reasonable support? Is it something that warrants looking into? And the quicker that you can notify your auditors is probably going to be better, generally speaking, because it's some of you have maybe gone through this. Auditors are going to involve their risk group. They're going to involve their forensic accounting group to shadow an investigation. And they're going to want to have input from the very beginning. And so if you're too far down the line on doing an investigation, you may have missed steps that the auditors wanted you to do as far as the breadth of your preservation of documents, who was going to be interviewed, and there may have just been things that you can't go back and fix. And so having the auditors involved earlier, and especially having their shadow investigators having input, is going to be lead to hopefully more successful resolution, because at the end of the day, the company's looking to get an audit opinion. And so they're going to need to satisfy their auditors that the investigation was not only to the soundness of the conclusions, but the process that was undertaken, and getting them involved from the earlier rather than later is going to potentially hopefully get you there easier. It looks like we have Mike back. That's great. Good timing, Mike. One thing I wanted to ask you, Mike, was we were talking about how to handle investigations relating to senior management or illegal activity, and maybe just from the government side, since you bring that experience, talk a little bit about what the expectations are about escalating those matters to either the board or the audit committee.
Yeah, I mean, you have to proceed from the assumption that it may very well be that the government is going to want to talk to the audit committee members themselves about what they knew or didn't know about a particular set of facts. And obviously you don't want them to be surprised when they hear from the government potentially later on. And so, the SEC would, I know that during my time there, they would expect that those matters that are within the jurisdiction and authority of your audit committee are being reported to them, and that they're aware of matters that are potentially have a material impact on the company, right? Matters involving potential intentional misconduct by senior level executives, as well as matters that have the potential to adversely materially affect a company's reputation, as well as matters that could have a quantitative effect on the company if it had to move to settlement. They're going to expect that you've escalated those things, and I think in most instances, if the government is involved, particularly the SEC or DOJ, then you've probably already done that. But that's sort of table stakes for them. They also may expect that, depending on the nature of the allegation, that the audit committee might have their own counsel if they have a sense that there are senior people involved, and the interests of senior executives may not be necessarily aligned with the interests of the audit committee members themselves.
Matthew, let me just jump in and just say, with regards to that, I think what that underscores is the importance of developing a positive working relationship between the compliance office and the board audit committee. If you know what it is they want to hear, if they're comfortable in how you're approaching things and what you're doing, if there's a good relationship which is existing, that's the proper framework for you then to be able to go in. You don't want to be surprising people. You want them to have a level of comfort that you're handling things professionally, diligently, aggressively, and correctly. So I think that just underscores how important it is for the chairman of your board audit committee and your chief compliance officer to be able to work together well.
Yeah, and it certainly fulfills the expectations of the government. I mean, we've talked about it, and we're going to continue to talk about the DOJ guidance. I'm sure it's been talked about in this conference. It's included in our materials for this, but it's actually quite good guidance on the expectations of an effective compliance program, and having that board oversee the compliance program at the appropriate level is certainly one of their expectations, and it's good practice. Well, let's move on. Let's talk now about some issues in conducting investigations. And, given the two of you in your background, I want to start off talking about international considerations. And so, David, let me ask you, being, so long in the Middle East, could you talk about just some of the things you ran into as far as local laws and customs, and, who conducts the investigation, how that may change outside of the U.S.?
Sure. I mean, obviously, I come to this with a very different perspective, one of having been counsel for a national oil company. So not only being outside of the United States, but our shareholder being a foreign government and working in that environment. The most critical piece of advice that I could give someone who's going to be conducting an investigation regarding facts or elements which occurred outside of the United States is how important it is to know and to understand both local laws and customs. So I can just give some perspective and some examples just from the world that I just returned from a month ago, is that, for instance, if you're investigating an FCPA violation, at the same time, you need to know that you're probably investigating an SFO UK Bribery Act violation. You're probably looking at the bribery law of the local country. So in Saudi Arabia, there's the Saudi bribery law. The Saudi bribery law and the FCPA are not the same. You could have a violation of one and not the other. So it's important that you be investigating and determining whether the elements of either or both have been satisfied. In your investigation, there are going to be requirements that you need to make certain that you're addressing. So for instance, there are requirements regarding the nationality of the investigator. So investigations in Saudi Arabia needed to have a Saudi investigator, a Saudi national involved. In many of the countries in that part of the world, you can get yourself into trouble if you're interviewing a woman and you do not have another woman in the room with you. It's important to know what the local laws are with regards to confessions. Someone who confesses to a violation, that may not constitute a true and adequate confession. There are other requirements that need to be met. Was it done in writing? Were they given proper warnings? If you're going to record an interview, there are requirements that need to be filled. There's rules of evidence that you need to make certain that you're addressing. You need to know what the requirements are for potential interactions with foreign ministries or other regulatory agencies in those countries. And these are things that someone who doesn't practice in that area will not know about walking in. And so I think it's important to consider whether you need to get local counsel, someone who understands the laws and the customs of that country to guide you through that in order to protect yourself. The other issue has to do with whether or not it's important for you and what steps you need to take to preserve legal privileges that you think you may have. In the United States, we have a very elegant, sophisticated, and broad notion of attorney work product or attorney-client communications or work in anticipation of litigation. But in Europe, a lot of times in-house counsel is not afforded that same protection of legal privilege, and it's important that you have outside an external law firm providing that work in order to get the privilege. And in the Middle East and in Asia, the notion of legal privilege almost doesn't exist at all. And so it's important that you keep in mind what it is you're trying to protect and who you're trying to protect it from, how it might be used. And so you need to sometimes understand that you're working without a net beneath you, the net of legal privilege.
That's great. Well, I want to skip ahead a little bit from our outline, and I wanted to skip to talking a little bit about dealing with whistleblowers. And before we talk about that, we do have a polling question. So Casey, if you want to go ahead and post it, and then I'll read it. COVID-19 has had an unprecedented effect, to say the least, on operations of companies throughout the world, which for many has resulted in increased financial pressure, decreased compliance resources and budgets, and employees working remotely. So the question is, how has the pandemic impacted the volume of reports of potential wrongdoing from whatever source normally was received within your company? And the choices are simple. A, increased. B, the number of reports has decreased. Or C, there has been no significant change. While we're waiting on the results, I see if the two of you can guess what the answer might be. Just curious.
I'm going to say decrease. I think that people are not, they're not present in a physical workplace. They're perhaps feeling a little bit disconnected because so many of us are working remotely. So I'm going to go with decrease, but don't. I'm not putting any money on it, but I am going to go with decrease.
David,
I
what's
don't
your
know.
guess?
I think I would agree with Michael. I remember having a conversation with one of our the president of our company several years ago, and we noted that there had been an increase in the number of reports coming into the hotline. And but the question was, does that mean that we're less ethical than we used to be? Or does it just mean that we're better at finding it? So I'm not certain exactly what it is, probably a little of both. And that's why I always say the number of complaints or notices and investigations that come in through the hotline is not a good KPI. It's just a number. I'm not sure exactly what it's supposed to mean, but it's an important thing to have, obviously.
Great.
Yeah.
Casey, do we have the polling results yet?
Yes, we do. Okay, so we have 44% say no significant change, 44% say decreased, and 11% of our attendees say increased. So again, that's 44% for both no significant change and decreased, and then 11% for increased.
Wow.
That's pretty interesting.
Yeah.
Well, I think you guys you were right. It was interesting. Some of us were thinking that as a result of people having more time and maybe being a little concerned about maybe keeping their jobs, they wanted to raise issues, but maybe that actually hasn't proven the case. I still think if you're thinking about it from a fraud triangle, I suspect what we're going to see is maybe an increase in kind of misconduct coming to light. It's just a question of when that might come. And it may be from third-party contractors, for instance. But it'll be interesting to see how that develops. So we only have... Go ahead, Mike.
But no, they say that when you're thinking about fraud within your organization, one of the things you have to look for is employees who never want to take time off, because it may be that things will come to light once they're out of the office. And so you're exactly right, Matt. It may be that more things will be exposed now that we're all working from home.
Okay, let's move ahead. We only have about 10 minutes left. There's obviously a ton to talk about here. Let's talk a little bit about reporting. And Mike, why don't you talk a little bit from the government perspective of what is the expectation? I mean, there's always this issue of the form of the report. And I'm talking about a big investigation, meaty, you got outside counsel involved. And there's one issue, simple issue is, should you do a detailed written report, a PowerPoint, verbal only? But maybe you could talk about it from the government perspective, what those expectations are.
Yeah, I think that at least from the SEC's perspective, they were pretty realistic in their understanding that the days of a detailed 25-page written report, which contains an assortment of admissions, are probably, if those days ever existed, they're surely gone. It was my experience. I was in the FCPA unit that most of the time you would receive perhaps a presentation using the ubiquitous form of PowerPoint. But even the presentations themselves would be, sort of, there wasn't a lot in writing, or they wouldn't allow you to keep the presentation. The council would deliver it, but it was, it was available at their offices if you ever wanted to see it again. And so, but what the staff was looking for, and I think from both DOJ and SECs, they understand that there are certain realities associated with putting things in writing, but what they're looking for is your ability to work with them. Are you putting the effort in? Are we trying to working in good faith to find alternative ways to get them the information that they need, right? So if you're not comfortable producing interview memos, that's understandable, but are you going to give the government an oral briefing on what a particular witness said? The facts, right? Making it clear that this is, of course, not verbatim. This is, a distillation of just the facts. So that's really what they're looking for. They're looking for sort of a good faith effort on the part of companies and their attorneys to get them the information that they need. And that's especially true in the FCPA context, right? So neither DOJ or SEC can conduct law enforcement activities in foreign countries. And so especially in the context of an FCPA matter, company counsel, the work that company counsel is doing on the ground to conduct interviews and to gather relevant information is really going to be key to the government's investigation as well.
And then going back to the international, I mean, David, you were telling us that there's international considerations for why you may not want to do a written report. You want to share that?
Well, I think it's generally just the same privilege issues. You want to be careful about the record that you're making. And of course, if you disclose it to anyone, you're obviously going to be waiving privileges right off the beginning. So I think it's something that's important to be careful about the type of record that you create, knowing that depending on which country you're dealing with, if you're dealing with local authorities, if you're dealing in Europe, or if you're dealing wherever it might be, that the same privilege protections that you take for granted in the United States may not be in existence in other places. So you just need to be very careful, and you need to think about what type of record you create, just knowing that it might be something which becomes public.
And on that point, I'll note this one case that I think we all should be on the lookout for. It's SEC versus RPM International. It was a decision out of the DC U.S. District Court earlier this year, and it involved a very good law firm, Jones Day, providing a report to the external auditors. And in the context of that, they gave a summary of interviews that they conducted of certain of the witnesses. They weren't actually based upon their interview memos. They hadn't even done the memos at that point. And ultimately, the a court ordered that all of the council's interview memos be turned over to the SEC. A big part of it was the outside auditor had produced their notes of those meetings where they got the interview summaries. But the court went pretty broad on this. I think it's an outlier, but it just goes back to when you're giving that summary, you're giving this download to either the government or to the auditors of your notes. You got to think about waiver issues there. So, Casey, I notice we probably only have a couple more minutes, or if there's, let me know if there's any questions. If not, we'll wrap it up by talking about the last topic here.
Yes, we just have about 2 minutes left. So yes, please go ahead and just, you can wrap it up. Thank you.
Okay, great. So from a wrap-up standpoint, one thing, we talk about kind of the stages of investigation, and this particular one was titled from stem to stern, and it suggested that the reporting or final determination was the end of the investigation. One thing to keep in mind, though, is especially based on new DOJ guidance, it may not be, because you need to think about remediation and incorporating lessons learned. DOJ put out their guidance last year, but then recently updated it and really hit home on the notion of making sure you have effective remediation, and that includes taking what you learned from the investigation. If you detect problems that you need to implement additional controls or additional policies, the need to incorporate that in your compliance program. Maybe training is what it is. But remember, again, final determination really isn't the end. It is kind of following through and making sure that the compliance program doesn't have holes in it or doesn't need updating based upon what you learned in that investigation. Mike, David, any final words?
I would just say that whenever we had a compliance gap that we had detected, I think there are 5 important things that we needed to cover. One was reporting, to determine whether it needed to be reported to a local authority or to an international authority such as the SFO or SEC or DOJ, or to your own audit committee or to external auditors. The second thing is discipline. Do you need to discipline or reward an employee or a contractor or a vendor? Do you need to refer it for criminal sanctions? Do you need to take some sort of a civil action to recover damages? The third one is your policies and procedures. Have they been adequate? Could they be improved? How can we make it better or more clear? The fourth one is training. Have we just not adequately trained our people? Do we need to explain this better? Do we need to emphasize this? And then the final one is publication. Do we want to make certain that our employees understand that some of their coworkers did certain things and these were the consequences? And so, we would want to either report the investigation, perhaps anonymously, or even in a name and shame type of a scenario. So those are all important things to look at.
Well, looks like we're at our time. Thank you very much, Mike and David, for joining us. You guys have been great. Appreciate your insights, and thank you all for listening.